Given the fact that existing intellectual property laws were originally intended to incentivize creativity in a world where books, music, and other information had to be affixed to a physical object in order to spread. And now, thanks to the internet, we enjoy a world where information travels without being affixed to any physical object. So should we rethink our old system? So in other words, is the balance that was struck in the industrial age between creators and the public, is that the right balance for the information age? Does anyone in the panel have a comment?
What we're seeing now is not just policymakers, lawmakers, and the public, as well as technology companies struggling with how do you interpret that balance, but we're also seeing courts get into the action as well. I mean, that's really, maybe I'm just an irrepressible optimist, but I've seen courts in the United States interpret the DMCA, which a lot of people think is this horrible, evil thing, fairly restrictively to tie, like I said, to copyright law. There's a case in the United Kingdom where a court has had to deal with the Human Rights Act, which implements the European Convention of Human Rights, and whether that fits into a public interest exception for copyright law. So we're starting to see that permeate in the courts, and we're starting to see maybe some kinds of guidelines and best practices develop from rather unexpected fora like the courts.